Hello and welcome to Liberty Nation's LNTV. It's been a big week in the Supreme Court as for the first time in a long time, they've heard a case that relates to the Second Amendment. To join us to discuss this is Liberty Nation's Legal Affairs Editor, Mr. Scott DeCosenza. Welcome.
Cheers, Mark.
So Scott, what's this case about?
This case is about the exceedingly restrictive, really fantastically restrictive controls that New York City places upon people who wish to own a firearm in that city. The main restriction that's being fought is the ability to take that firearm from one's home to another place, a nearby range that may be outside the city, a vacation property, your brother-in-law's farm, doesn't matter where, someplace outside your home. New York City forbids that for almost every type of gun license that it issues. And those people say this is a violation of my Second Amendment rights.
Okay, and how did that issue fare at the court?
Well, we've only had oral arguments, so we're going to have to wait and see for the judgment. But we know that most of the time spent and the sort of fireworks at oral argument were spent not over whether that law itself was part of, could be legal under the Second Amendment, Mark, but this issue of mootness. And how that comes into play is that the gun control advocates were so afraid that the Supreme Court might broaden the protections that have been granted under the landmark Heller ruling and then its legacy of McDonald, that they wanted to change the law so that the Supreme Court didn't have the chance to. So what they did was they changed their own law in order to say to the Supreme Court, see, the law's changed now. We don't have this problem anymore. You don't have to address this case.
Okay, so that is the mootness. It's now in their mind become a moot point to actually for the Supreme Court to hear this case anyway.
Well, the Supreme Court only hears actual cases and controversies. It doesn't hear hypothetical challenges. So
Sure.
what the gun control advocates are saying is this case is now moot because of that law change, and you therefore should not rule because it's not an actual case in controversy. Now, when the Supreme Court took the case, they actually had briefs submitted on the mootness point after the law was changed. So the Supreme Court, Mark, here's the timeline. The Supreme Court says, okay, we're gonna accept this challenge and we're gonna hear this case. Then the city changes the law. Then the city says to the Supreme Court, please don't hear this case. You can't hear this case. It's moot. And the Supreme Court says, and then the gun rights people say, no, it's not moot. And the reason why is because they could change the law back. And also there are maybe penalties that go forward for people who have already been convicted basically of breaking this law. So the Supreme Court, when they heard the oral argument on this case, spent most of their time and effort, it seems like, delving into this mootness issue rather than the Second Amendment issue.
So Scott, how do you think the court will eventually rule on this?
Well, I think, Mark, that the mootness issue should be ruled on, that the case is not moot because of the consequences that people have already had visited upon them because of non-compliance to this rule. And also, they could change the rule back tomorrow. I mean, it was just basically an NYPD commander who sort of changed the rule, and they could change it back. And the other thing is, what about the people who live in other cities with other issues that are similar to this? The famous case of Roe v. Wade was not declared moot simply because that pregnancy ended before the case got to the Supreme Court. They heard it because they knew that it was going to occur again and again. And there are many places that while New York City perhaps is the most restrictive, there are other restrictions in place. And I think it's sound policy for the Supreme Court to not basically grant a veto to the government. And what I mean by that, Mark, is they designed their law in order to take the case from the Supreme Court. It was not some sort of genuine attempt at lawmaking. It was just, hey, let's change this real quick so the court doesn't rule. And I think the court might do well to assert its independence by saying, we're going to see this case anyway. And then we get to the Second Amendment issue itself. And wow, that's an easy one in terms of, does this law, which has been changed, pass constitutional muster? It seems quite clearly that it doesn't. Unless the Supreme Court only gives a person the right to keep and bear arms in their own home, then surely they may be able to take that firearm in a locked container, disassembled and separate from any ammunition in the trunk of their car, to another place within the same state. which is, of course, why there was so much fear and trepidation from the gun controllers for the Supreme Court taking the case in the first place.
Very interesting case, Scott. Thank you for joining us.
Cheers. Thank you, Mark.
Hi, folks. Lisa K. Donner here, editor-in-chief of LibertyNation.com. We hope you enjoyed watching this video, maybe even learned a thing or two. If so, please take a moment and subscribe to our YouTube channel right down there in the corner. Thanks so much.